Welcome to the fourth in our series of 4 short videos in which we take a bite-sized look at some of the ways in which litigation and court orders can affect parties who are not participants in the relevant litigation. Anyone who holds data or information about third parties may be subject to disclosure orders in litigation. In today's video, Jonathan Kirsop, a partner in our corporate team, will outline how data protection and freedom of information regimes work in this context.
Anyone who holds data about third parties may be subject to disclosure orders in litigation. In this segment, I will examine how the UK data protection regime applies to regulate the information disclosed. In addition, I will briefly look at the analogous situation where a public authority receives a freedom of information request which relates to a third party's information. Firstly, it is worth understanding what is covered by the Data Protection Act, or DPA. The DPA governs the storage, use, disclosure, receipt, or other handling of personal data by data controllers established in the UK. Personal data is information stored electronically or in a structured hard copy file which relates to a living and identifiable individual. Information that relates to someone is information that can be used to learn, record, or decide something about that person or could otherwise affect them. This could range from low-level information, such as a person's business contact details and email address, to more important data, such as that relating to the individual's bank account, salary, or health. It may also include an opinion about an individual expressed by someone else, something that may be relevant in the litigation context. The information need only be capable of identifying an individual, including in conjunction with other information, to constitute personal data. So information such as passport numbers, driving license numbers, and ISP addresses have all been held to be personal data. Certain personal data is defined as sensitive personal data, namely personal data which relates to race, political opinions, religious beliefs, trade union membership, health, sexual life, and criminal or alleged criminal offences. And the DPA imposes additional restrictions on how this sensitive data is handled. The DPA applies to any data controller who is established in the UK and who uses, stores, receives, or discloses the information in the context of that UK establishment. A data controller is the party who determines the manner and purposes for which the information is to be used, and established is widely defined and would cover subsidiaries, branches or offices, as well as entities incorporated in the UK. There are also some limited provisions applying jurisdiction where equipment such as servers are used by a non-EEA company to process data in the UK. So, what obligations does the DPA impose on data controllers? Data controllers must firstly be registered with the ICO and comply with the 8 data protection principles, which include treating personal data fairly and lawfully, handling the data in accordance with specified and lawful purposes, and having appropriate security measures in place. There are also restrictions on transferring personal data to jurisdictions outside of the European Economic Area. Turning now to how these requirements interrelate to disclosure rules in litigation. In the United Kingdom, it is usual for the court to order that the parties give standard disclosure. In this situation, each party will be under an obligation to disclose documents which are or have been in its control and which relate to the dispute, whether or not they support or adversely affect their case. The obligation is not limited to documents which a party has or had in its possession, but also documents which a party has or had a legal right to possess or inspect. For example, documents held by professional advisors such as accountants or lawyers. The definition of document is very wide and includes all media in which information of any description is recorded. In order to comply with this obligation, the parties will need to conduct a reasonable and proportional search for documents. What amounts to a reasonable search will depend upon the facts of each case, but factors such as the volume of documents involved, the ease and expense of retrieval of documents, and the nature and complexity of the case will all be considered. This disclosure search often involves a review of email data, and whilst keyword searches can be used to filter the number of documents to be reviewed, it is inevitable that such documents will contain personal data. So can personal data relating to third parties be disclosed under the disclosure rules without breaching the DPA? Section 35 of the DPA provides a limited exemption to the so-called non-disclosure requirements, where disclosure is required by the order of the court. An order for disclosure would therefore engage this section. However, in most cases, in order for the disclosure to be fair and lawful, it must be necessary that the personal data elements of the information be disclosed in connection with the satisfaction of the disclosure orders. Even where this exemption applies, the grounds of Schedule 2 for non-sensitive data or Schedule 3 for sensitive data will also need to be satisfied. In the context of disclosure, it may be that the processing is necessary to comply with the legal obligation, i.e. the disclosure order, or otherwise in connection with legal proceedings. Again, the key is necessity. Clearly, where the data relates, say, to the employees of a third party to proceedings, the necessity test may be harder to satisfy than where it relates to individuals within an organisation. For instance, it will not be necessary that all emails of a third party, or even defendant, to an action are disclosed, where only a proportion of those relate to the issue at dispute. What about overseas actions? The 8th data protection principle states that personal data must not be transferred, which would include being accessed remotely, outside of the EEA, to a jurisdiction which does not provide adequate protection to that personal data. Only a handful of territories have been deemed by the EC as having laws which provide adequate protection. Notable by their absence from that list are the United States and India. So where transferring personal data to other countries, you would need to consider the exemptions and other grounds for legitimate transfer. Note that Section 35 does not provide an exemption to the 8th principle, so the most relevant exemption is where the transfer is necessary in connection with legal proceedings, including those overseas, for obtaining legal advice or for otherwise defending legal rights. Issues to consider would be whether it is necessary for all personal data to be sent to the overseas country, or whether a relevance test could be conducted in the UK before being transferred and the information sent over only once extraneous personal data had been redacted, made anonymous, or removed. Some tips for compliance with disclosure rules. Do not disclose large quantities of information without first evaluating whether personal data is contained within. If personal data is contained, consider whether it is relevant to the case and necessary to disclose. Be particularly careful with respect to disclosing sensitive personal data, as the grounds for authorised use will be more narrowly interpreted and quantum of any damage caused by an unlawful disclosure may be greater. If the proceedings are overseas but a large amount of information resides in the UK, consider conducting a relevance test in the UK so as to minimise transfers of personal data outside of the EEA to that necessary. Finally, I wanted to briefly touch on the impact of the Freedom of Information Act 2000 on third parties where their information is held by a public authority. The Freedom of Information Act applies to public authorities being public bodies such as government departments, councils, or state-owned organisations which are listed in the Act or otherwise providing a defined public service. Regulators such as the FCA are captured by its rules. FOIA grants a right of access to all information held by a public authority subject to certain exemptions. The right is freestanding, purpose-blind, and disclosure is deemed to be to the world. Various exemptions apply, some qualified by a public interest test and some absolute, including where information is available by other means, it relates to the formulation of government policy, or it is prohibited under enactment, which would cover some confidential disclosures to the FCA under FISMA, for example. Most often debated in the context of third-party information are the exemptions of confidentiality and commercial interests. Section 41 provides an absolute exemption for the disclosure of any information held by a public authority, the disclosure of which would constitute an actionable breach of confidence, i.e., information held under a legal duty of confidence will be exempt from disclosure. A breach of confidence is actionable if the information has the necessary quality of confidence, for example, it's not in the public domain, it is given in circumstances under an obligation of confidence, and there is an unauthorised use of the information. Section 41 is an absolute exemption. This means there is no public interest test under FOIA. However, the public interest does come into consideration within the definition of a breach of confidence, on the basis that a breach of confidence is not actionable if the person has provided consent, there is a legal requirement, or it is in the public interest to disclose. Therefore, consideration of the public interest is still relevant in this exemption, just applied differently. The presumption is that the information would remain confidential, whereas when interpreting it in the context of qualified exemptions, the presumption is in favour of disclosure. For these reasons, namely that information must have the necessary quality of confidence, there is a danger in assuming all information marked as confidential will be covered by the exemption. If the confident exemption does not apply, Section 43 provides another exemption where release of the information is a trade secret or would prejudice the commercial interests of a party, either the public authority or a third party. This is a qualified exemption. Even if release of the information would prejudice the party's commercial interests, if the public interest in disclosure outweighs this, then the information must be disclosed. In the case of John Connor Press Associates Limited and the Information Commissioner, likely to prejudice was held to mean evidence of a real and significant risk of prejudice. In other words, very strong arguments are needed in order to justify withholding information under Section 43. Accordingly, it is safer to ensure you have taken the necessary steps to ensure confidence, and therefore Section 41 would apply. To conclude, some steps that third parties can take to limit the likelihood of its information being disclosed under FOIA. Firstly, establish a record of what is given to which public authority, on what basis, and who within the organisation is responsible for signing off the provision of this information. This can help ensure that unnecessary or overly detailed information is not provided. Secondly, analyse the confidentiality and risk of providing information. Some documents will always be confidential, such as product designs, development plans, marketing strategies. Other data may only be confidential in certain contexts, such as planning permissions and consents for a new plant. Finally, organisations should create guidelines on asserting claims for confidentiality, the drafting and use of confidentiality agreements, and contracting with public authorities, so that the risk of inadvertent disclosure is mitigated to the greatest extent possible.